Good morning and welcome to today's Ask a Pro webinar. Today's topic is what is your collateral recovery and Replevin strategy? My name's Reis. I'm a shareholder here at Weltman Weinberg and Reis. I work out of our firm's Columbus office. I've been with the firm about 47 years, and at this time my practice generally revolves around collateral recovery and Replevin issues. My group also manages a national network of attorneys so that we are able to provide Replevin services across the country. I have a group of legal assistants who interface with local attorneys to provide those kinds of Replevin services. And I also practice in Ohio. My license is in Ohio, and so I do practice in the collection and collateral recovery area in the state of Ohio. With us today also is Amy Clum Holbrook, and I'd like her to introduce herself at this time.
Good morning, and thank you all for attending today. Like Al said, I'm Amy Holbrook. I'm also an Ohio lawyer, but I'm a little further north. I'm up in the Cleveland area. I help manage our litigation and complex collections department here at the firm, and part of my role, or my primary role, is in the realm of collateral discovery or collateral recovery. And I think I know a few of you on the line today, and I'm excited to talk with you. I've been with the firm about 21 years this December, and I am pleased to pass the microphone over to Stefanie Kempfer Collier.
Thank you. Good morning, everyone. I'm excited to be here and glad you're all here with us. I'm Stefanie Collier. I practice out of Indianapolis, and I'm licensed in Indiana, Ohio, and Illinois. I mainly handle all things collateral recovery from Replevin matters, repossession questions, compliance-related issues, for letter reviews, all things that auto that we're going to talk about today. So excited to get going.
Thank you, Amy. Stephanie and I are looking forward to discussing your questions about Replevins and collateral recovery. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel, and I'll do my best to handle the technology to pick up on those questions. Questions can be addressed during the presentation where applicable. The webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a short survey on your screen at the conclusion of the event. We'd appreciate if you would please fill out the survey and share your feedback. We greatly appreciate your opinions on our webinars. So let's get to the first question. So our first question is sort of in order of how one of these cases proceeds. What is the process once a person states that they want to file a Replevin, and how long does it take to complete from start to finish? So I'm going to throw this question to Amy to get us started with how the Replevin decision-making begins.
So the chances are you've made an auto loan, which the majority of the cases are auto, but they're not limited to auto, and that loan has gone bad for some reason. There's been some form of breach that now the recovery includes not only trying to get the money that's owed back, but also getting back the collateral that secured the loan. So step one really is to make sure you've got a really firm reason for default, and that's usually pretty clear. Occasionally it becomes a little more opaque. If that breach is a lack of payment, or if the breach is loss of insurance, there's any number of other things that can result in a breach. But once you've identified it, the next thing is taking the time to figure out what your collateral is worth. On auto, that's easy, right? That's an NADA evaluation, making sure the vehicle is worth the money and the time. Now we're always going with an estimate. We don't know the condition. Oftentimes the consumer or the member left the vehicle in, but to make sure that that collateral is worth the time to go after. Also, sort of figuring out who has your collateral and being able to identify that and provide it to us. So the first thing when you call me and say, or Al or Stephanie, and say, hey, I want to file a Replevin, those are the questions we're going to ask you. What's your collateral worth? Who do you think has it? Where is it located? And what does your loan documentation look like? Is our loan complete? Do we have the full document? What's our security interest in the vehicle? Those kind of things, like, do we have a copy of the title? Do we have some documentation of our security interest? So we're going to ask you to provide that data to us, because in most states, you're going to need to file an affidavit or a verification stating that certain things are true, that we have a loan, we have an interest, this is how we secured it, and what's our collateral worth. So you'll tell us that, and then it'll come over to our team for setup, and we'll get it set up. In the new world, everything's a little slower when we're seeking a monetary judgment in particular. Many of you on this call probably have heard of the MVN, the Model Validation Notice required by the CFPB. Weltman is a debt collector, as are any other firms engaged in the process of collecting debt on your behalf, which means we have to send out a model validation notice. We'll have you complete a form for us so we can send that letter out, and then the clock starts to tick. So ideally, you'll refer the file. We'll get that MVN out within the first 3 to 4 days, and then we start the clock and we wait. We wait about 40 days for that letter to expire. So we've got 40 days on the calendar. Then in that time, we'll be drafting up your complaint, your affidavit, and your motion. And Stefan and Al will talk a little bit about the differences in the states they have exposure to. Not every state has this motion that goes out at the same time, but we'll start the prep. So on day 40, ideally, after that MVN has gone out, we'll file our complaint. And that's the process for getting the court to award us the right to take back possession. So we filed it, now we have to perfect service. Most of us are using Sheriff service, which makes things go a little faster, or special process server. So service takes anywhere, if you provide us with good data, we can move a little faster. We can usually get service fairly quickly, and then the court's going to set a hearing. So from the day we file until the day of the hearing, if there's a motion hearing, for instance, in Pennsylvania, there's not. And sometimes Steph can talk about the difference in what goes on in Indiana, where we have a short answer time. We'll get the complaint filed, we'll get a hearing set, and then there's about 28 days the defendant gets to file an answer after they're served. If they don't file an answer, we can move for default. On average, a Replevin takes about anywhere from 90 to 180 days, depending on how fast our courts are working. Some of it is beyond our control. Courts set hearings as they set hearings. So we are sometimes in their hands when it comes to that kind of thing. But, and service is key, because if we get into a battle where we can't find someone, then it's going to take a little longer. At the conclusion of a case, too, we will file what's called a writ, which is a fancy lawyer word for instruction, for the court to have the sheriff go out, or the constable or the bailiff go out and pick up our vehicle for us, or go tag it. And those writs are alive for about 60 days on average. So when we give it to the sheriff, remember that sheriff has got a ton of exciting things to do besides serve up my Replevin writs. He's got to go serve warrants. Sometimes he's got traffic obligations. So they try to slip us in, and for 60 days, they're going to go out and try and find our vehicle. A good Replevin case, again, is about 90 to 180 days. I don't know if Steph or Al want to throw anything in that I may have omitted.
Well, I'll just add a couple of comments. That's an excellent rundown of how the legal process works, but keep in mind that an excellent way to shorten the timeline to get success with the Replevin is the fact that when your customer gets served, many times they will call you as a result of being served with this complaint. And it gives you a tremendous opportunity to take advantage of that contact to resolve the issue with your customer, either a way to get the customer to bring the loan current, or voluntarily turn in the vehicle. So the Replevin can be filed and resolved very quickly if you can establish that communication with the customer. On the back end, the Replevin can get bogged down in legal issues and get bogged down in litigation if your customer hires an attorney and essentially fights the Replevin. At that point, as Amy indicated, you're subject to whatever the court's schedule looks like and how busy that judge is, and so the Replevin can take much longer based on cases that become contested. And I'll stop here for 1 second, unless Stephanie has something to add.
She just to add to that, that you can always have your repossession agent still out there looking for the vehicle as well. Sometimes, as Al said, when you get a customer that calls in, they may give us a better address. They may even give us a location of the vehicle, and then you can have your repo agent go out and pick up the car. So it's always really good to be in contact with the customer because they could give us location information, which will then help the process along. And then also just to add, in Indiana, I don't typically file the motion that Amy had mentioned, the immediate motion for temporary possession, just because Indiana has a shortened service deadline. That I've just found that it is easier to proceed ahead to final judgment here in Indiana than to wait for that court's temporary order, where we can just get the final order processed, entered with the court, and then start the writ process with the sheriff. So yeah, but otherwise similar timelines here in Indiana. Again, it just depends on if we have service issues, other legal issues that may come up. Maybe somebody else, a third party, might suddenly have our vehicle. There's all sorts of things that can kind of hamper that timeline.
So a question has come through the chat, so I'll take a little detour here. The question is, can the lender pursue the debtor for interest which has accrued up to the point of repossession? The answer is yes. Obviously the lender is entitled to all of the principal and interest that accrues under the terms of the contract, the loan agreement. So whatever applies can be added to the eventual judgment or added to the amount necessary to bring that loan current. A second question came in. Let me just scroll back up here just for a second.
Well, I was doing that. I know since our way that if you have prior repossession fees, because you've picked this car up once before, or if you have late fees, those are important things to give over to us too, because you may be entitled to those as well.
Thank you. One other question here. If we obtain a final order of replevin and damages and then find out the asset is in another state, could we domesticate the order in the other state and then go after the asset? The answer is, in general, yes. In general, every state is required to give full faith and credit to orders of the other states. And so if you have a final order of possession and determine that the vehicle is actually in a different state, you should be able to obtain an exemplified copy of that judgment, transfer it to the other state. However, then you are going to be required to at least follow the procedure in that other state to execute that order by taking possession of the vehicle. Okay, and this is a good question for Stefanie. Is it absolutely required to wait the 30 days if you're only filing a one-count complaint for possession?
Is this regarding the model validation notice?
I'm assuming that's the question, yes.
So if it's just if you're just asking for possession, it's going to be state specific, but we have determined that in Ohio and Indiana that we are not sending out for the most part, not sending out the model validation notices for a possession only replevin. So we are not asking for any monetary damages as part of that as part of that judgment.
There's an overall lack of guidance from the CFPB regarding whether or not replevin is true debt collection. Historically, we as a firm have sort of followed some case law guidance that a strict replevin isn't straight debt collection. You're actually enforcing a security interest that you maintain. That are not sending an MVN may change in the future if further guidance is provided, but at the moment we are not.
We will be out. Actually, Amy and I are going to a conference in November, and we obtained a attendee list where representatives from the CFPB will be there. And so we are actually going to find them and ask them this exact question, because we would like guidance, and it would be really helpful if we had further guidance. That way we can let our clients know, and then we can be compliant with the law.
Well, thank you. Our next question. What's the general cost to file for replevin? I guess I'll start this one. And so there are two components basically to the cost of filing the replevin. It is the actual court costs, amounts that have to go to the court or sheriff to accomplish the replevin. And the other is the fee that you're going to pay to a lawyer to file that replevin for you. And In general, I'm going to tell you that the total cost and fees beginning to end are going to generally be in that $1,500 to $2,000 range. And the comment that I wanted to make is that our rule of thumb over the years of many years of practice has been, in general, in the collection Replevin arena, if your costs and fees are going to exceed about 10% of the amount that's due, you have to think twice about whether it makes sense to expend the fees and costs necessary to accomplish that goal. So it tells us, in general, as clients ask, in general, we look at that $1,500 to $2,000 range for the value of the vehicle, which would justify paying fees of $1,500 to $2,000 to get the vehicle back. So the cost to file the Replevin, the answer to the question sort of goes along with a decision as to whether or not expending the cost makes sense in your case. Amy, do you have anything else?
No, just other than that, there's always a caveat that when you walk into a courtroom and you file something, there's always a chance that the matter will become litigated. In Replevins, it doesn't happen often, but for anybody who's on the call who's experienced it, it can happen, and then the costs do go up. But it is, like I said, when we start to evaluate a case for suit and whether it's worthy of the risk, right, of entering into the courtroom, that's one of the things we look at. And but by and large, between $1,500 and $2,000 is an adequate all in how much it will cost.
And just to add, you don't have to go after your collateral. A lot of clients, I think, assume that they have to take back the collateral. And if it's not worth it, as Amy started out the presentation with, what's your NADA value? Then you might just want to seek a monetary judgment based on your balance. You don't have to take back the collateral if it's going to cost you more to litigate and more to file your Replevin than what it's worth. So that's always an option, just to go after your balance and just leave that collateral out there.
We also talk a lot about cars, but sometimes your collateral isn't a car. Sometimes your collateral is equipment in a restaurant, or it's a copy machine, or it's something big. The other thing you kind of have to weigh about the cost is you also have to pay to remove it and sell it. So those are costs that can increase, but if the collateral is worth it, then moving that big item or selling that unusual item is worth it.
So a follow-up question came through the chat. Can the creditor pursue the debtor for the cost of the Replevin, the $1,500 to $2,000 that I mentioned, in addition to all else that is owed? Stefanie, what do you think?
So in Indiana, we can ask for attorney's fees as long as your contract allows for it. Most contracts I see on a daily basis do have a provision providing for attorney's fees. So we can request them and obtain them in the final judgment order here in Indiana.
Here in the great state of Ohio, consumer cases you may not ask for your attorney's fees. But in the commercial litigation arena, which Al's an expert at, and I'm sure he'll elaborate, as long as you provide for it in the contract, we can seek it. So in Ohio, you can get your court costs, but the fees for hiring your attorney on consumer matters generally can't be obtained.
And I guess I could add that across the country, I think the states are just about split in terms of some states granting attorney fees to the plaintiff, and in the other half of the states, they follow the sort of American rule like Ohio, where attorney's fees are not recoverable. But in any event, actual court costs are generally granted as part of the judgment for possession. So the cost portion of it can be recovered, I think, in every state. Okay, so I have some more chats coming through. I'm trying to keep up with them. Is it our responsibility to have the repo agent coordinate with the sheriff?
That's going to depend. That'll depend on your jurisdiction. So in rural Ohio, I'm always astounded that the sheriff will go out with a truck and tow it, and sometimes before I've even asked him to. They're very excited to get my Replevin order and to execute out on it. In other jurisdictions, what will end up happening is we'll ask you when we're doing the writ, who's your recovery agent? because our intention is to attach that to the writ so that we can tell the sheriff when you get this car, or you tag it, which is what some of them do, or if it's someone they know, they might just tell them, leave it here, the agent's coming for it. So it really is a jurisdictional kind of split, at least in my perspective.
The same. It's the exact same in Indiana. The rural county sheriffs will get a writ and will go out within hours and pick it up, and some have towed it. And here in Indianapolis, it is a waiting process. It's long and tedious, and so it's better to have your repo agent working directly with the sheriff.
And I think, as we will see, in general, the sheriff's deputies, sheriff's departments in small counties are much more engaged in this process than the large counties. For obvious reasons, it's just a matter of time and availability. But in a smaller county, the sheriff will be much more engaged in both locating and in, as Amy mentioned, in picking up the collateral. And I'm speaking from experience in Ohio, but I'm relatively certain that it takes place the same way across the country. All right, how about question number 3? When do I need to send a Replevin over? Stephanie, how about you?
Well, when you send a Replevin over, we're going to need a copy of your contract, a copy of your title. If you don't have a title, then we're going to need to have to fix that issue first. We're also going to need your payment history, or at least some sort of the reason for your default. So if it's a lack of insurance, but typically we see these for non-payment. So payment history that's going to establish the default, and then your balance. If you are going to be seeking a monetary judgment as part of the Replevin, we will need that as well to start the process. We're also going to need the address. We're going to have to know who has the collateral, and then where we're going to have to file this Replevin action, and then who we're going to have to serve. So it's important to have the information as to who has the vehicle and what the address is.
I throw in too that we like your repo results, particularly if there's been some kind of violence in relation to what the repo agent's gone through up until this point. Remember, we're sending out special process servers who are really just individuals appointed by the court. If we're sending them into a situation where someone's pulled a gun or there's been some kind of physical threat, we like to let our process servers know so they're safe, or we'll alternatively use the sheriff. Also, I want to mention just e-titling. For all my Ohio people, Ohio is an e-title state, but we have at least 2 major jurisdictions up north where I am that don't honor e-titles. So we have to reduce those e-titles to paper titles in order to file a Replevin action. And just for reference, that's Summit and Cuyahoga County now. For a long time, it was always Cuyahoga. Summit changed over just this summer, which means that we have to get a paper title or they won't let us file even. So while e-titling is great and for dealers and whatnot, it's not so great sometimes for the Replevin action.
And in Southern Ohio, we've had no problems with the e-titles. We have no courts, at least to my knowledge, that have required paper titles to support the Replevin process. All right, how about question number 4? How do you take advantage of the call that comes in from the customer after the Replevin is filed? I'll start this one off. We can't emphasize enough the importance of being prepared for and taking advantage of the call that almost inevitably comes in from your customer borrower after the Replevin is filed and after they get served. Inevitably, they'll call either with a request to forbear, or they'll make some kind of a proposal. But the key thing is that your staff needs to be aware of the fact that this proceeding has started. They need to be familiar with the loan, and they need to be prepared for the conversation that's going to take place. And so there's something very specific that your organization expects when they make the decision and spend the money to file a Replevin. And so it's important that you be prepared for the conversation that you're going to have with that customer when they call in. So from the standpoint of the Replevin itself, what is your organization prepared to do to allow the customer to remain in possession of that vehicle? In other words, how much and when do they have to make the payment in order to retain possession? And that should be a very calm and professional discussion. There's something specific that you need in order to refrain from taking possession of that vehicle. Or it may be that the delinquency is so severe that the organization has made the decision that there is no arrangement short of paying the loan in full that will allow them to remain in possession of the vehicle. That message needs to be sent very clearly during that conversation. And please refrain from being in a situation where you cannot deliver that message during that phone call. Taking messages, attempting to call back, attempting to re-engage that customer after that one opportunity, which is very important, is not productive. And so we strongly recommend that your staff be prepared for the call that comes in. Secondly, you want to make sure that your staff never promises to dismiss the Replevin once it's filed. You spent a lot of money to get this far, and the customer may or may not be prepared to pay what you're asking them to pay, but you are not going to simply dismiss the Replevin unless they are paying the loan in full. So you always want to, your staff always wants to remind the customer that even though we have an arrangement and you're going to bring the loan and keep the loan current, you're going to have to enter into an agreement filed with the court that gives the organization permission to take possession of that vehicle if you ever default again. So it's called an agreed judgment. It's sort of a pocket judgment. It's one that you hold and in abeyance. And if there's ever a need or a default later, you have the opportunity to use that judgment to take possession without having to pay for another Replevin. So those two suggestions: be prepared for the call and never dismiss the Replevin. Anybody else have anything? Okay. All right, question number 5. Can I use a Replevin action to also get a money judgment? Amy can answer this one.
The answer is it depends on where you're at. Most states right now do allow for what's called, we call it a 2-count complaint here at Wellman, where we can seek a monetary judgment and the Replevin order at the same time. That whole arena of thought is based on the UCC, which is a section of the revised code in most states, and all states I think we've all accepted it, that says that a secured creditor is entitled to remedies that include reducing a claim to judgment and to regaining its collateral. So Al knows the outliers by heart, I think. At least Sherry, who works with them, does, because I occasionally have to ask. But you should be entitled to both. When you are in the position of asking yourself, should I file a 2-count or a 1-count? Should I ask my lawyer to do that for me? It is an internal business decision. Remember, if we sue for money, Steph clarified it, we're sending out an MVN, so that's going to slow it down a little bit. Some clients are in a really big hurry to get back collateral that's depreciating really quickly, and they don't want to wait. So we'll file that Replevin as a possession only. But you are reducing your overall court costs. If you're going to eventually possibly sue for a deficiency, you are going to waive that second suit and the cost and the risk. So like I said, every time you file, you expose yourself to counterclaim. So you file one suit, you get the order of possession, and you get your money judgment. That risk is reduced too. So it is a business decision that you kind of have to make about speed and about cost and risk at the end of the day.
And no, Amy, I do not have those states memorized. At last conversation, I think there are 13 states, if I remember, that require that you file a separate action for the deficiency after the Replevin is concluded. And even in states that allow both counts, possession and money, in the same suit, in a lot of cases, the judge will require that you recover and sell the vehicle and establish a deficiency before he will enter a judgment for that deficiency amount, as opposed to entering a judgment for the full amount. So you just have to work through whatever that particular jurisdiction requires. We have another chat that came through that is interesting. It's a little out of order, but I'll just throw it in here. The question is, we've seen a lot of auto loans where our liens are not perfected and the member ignores. What options do we have to fix the lien issues? So the situation is that you have a contract, a loan, and a security agreement with your member in the credit union case. And yet, because of issues at the dealership or the seller, the lien hasn't been properly noted and the credit union is not properly secured with a lien on the vehicle. Obviously, effort needs to be made to get the dealer to perform the obligations that they have. So most of you would have a dealer agreement that requires that the dealer produce the title and lien within a certain period of time. If they haven't done that, then the first step we usually take is to make demand on that dealer to comply with the obligations under the terms of the dealer agreement, or face a lawsuit to force them to comply. The other potential action that can be taken is that since you have a security agreement with the customer and the customer supposedly has title to the vehicle, you could file what's called a declaratory judgment action with a court and ask the judge to order that the Bureau of Motor Vehicles issue a title containing your lien, because that gives effect to the contract that you had with your customer, with your member. So there's a couple of different routes to take there, but it is a problem when the dealership fails to perform its functions under its agreement with you. I don't know if either one of you have seen any of those cases with issues.
Yes.
Lots of them. I've seen inadvertent too, where a title's been inadvertently mailed with the lien removed. I've seen bad payments come in, and we've released the lien too early, and now we've got floating out their car title. And Al's right. And the other thing that's sort of common is I go into a dealership with a car that still has a lien on it. I trade it, right? And I trade it in and buy a new car. And someone purchased my old car. And what happens is company one that had the lien doesn't remove its title, or it doesn't remove its lien. So now we've got two lenders, right? We've got a lender who's not notated, a lender who is notated, and possibly an off ownership. And sometimes it's a matter of a few good phone calls and some letters to the original lender to clean this up because they somehow have omitted it. And when that fails, it's a declaratory action to clean up the title to get everybody situated where they need to be. For our credit union people who are listening in finance companies, you've also probably got an angry member or customer who can't obtain plates to the vehicle or registration to the vehicle because they're not the titled owner. We work in conjunction with the person who's purchased the vehicle to get this all cleaned up, to get everyone sort of situated where they want to be. The other kind of one that comes in a lot, and Steph can probably talk about this, is you repo it thinking you have a lien, and then you go to get the repo title and find out, oh my, I do not have a lien. I think Steph has one right now, so.
I have a couple of them right now. It seems to be more and more common right now. And then, yeah, we have to either fix it with, maybe there's another lien holder. I have one of those right now where it's the original bank and never released their titles. So working with that original bank to get their lien released and get the title cleaned up. I've got a couple where we're also having to file declaratory actions just to clean up the title. So it's something we see on a almost daily basis right now. It's definitely frustrating, I know, for clients.
I think the thing to take away is that usually it's fixable. How much work it takes to get it fixed it varies, but when you see it, don't panic. All is not lost. Consult your attorney, see what solutions are out there for you.
Yeah, the delays I've seen lately, I've just been serving folks. I've been having just some issues with service and getting good service for the declaratory actions, and that's sort of caused delays. But usually everything's fixable. We just need to notify. So especially some of these original owners that sold their vehicles but are still the titled owners, who probably don't even know that they're still the titled owners. So just some service issues.
All right, thank you. Another chat came through. With rising loan balances, are you seeing an increase in the use of Replevins given the higher outstanding balances? And the answer, I think, is without a doubt, yes. We're seeing a much higher influx of these kind of cases. There's more dollars involved. There's much more valuable collateral involved, and consumers especially are under pressure to make larger payments over longer periods of time, and so we're seeing increasing delinquency rates as well. And as a consequence of the fact that more and more of these high value vehicles are being repossessed, now that used car rates have drifted downward again, we're seeing some very large deficiency balances come through after the sale and auction of collateral. So deficiencies of $25,000 and $35,000 are not unusual anymore, unfortunately. I don't know if the two of you have seen the same thing.
Yeah, loan lengths are just the thing I think I've noted the most. And when we were doing this 5 years ago, a loan was 36 months, 48. Now the standard loan I see it come across my desk is 72 or 84. And that's just a lot longer time to default. And collateral is holding its value, which means, used car market has fallen slightly, but it's still very strong. So yeah, there's been an influx of work related to that.
Agreed. I would say that lately the deficiencies I've been seeing come in have been auto loans taken out in 2022. So it's the 6-month delinquency, picking up the vehicle, and I agree, Al, it's deficiency balances that have been unusually high.
I think the other thing that we're seeing is that there are more Replevins being filed to get collateral because there are fewer repo agencies in business, and the repo agencies that are in business, obviously under some strict protocols, and it's an increasingly dangerous business for repossession companies, and as a result, they are enjoying less success, I believe, than they might have in the past. And so the spillover is to actually take the legal action to get the vehicle as opposed to a involuntary repossession. All right, number 6. Why is service and location so important? And I'll chime in here first. Service and location is everything when it comes to a Replevin. If we can't get service on the customer, the case can't move forward. And the other thing that I have always emphasized is the fact that in a Replevin case, as opposed to a general lawsuit that you might file to get money from a consumer, in a Replevin case, you actually have to serve the consumer twice. So when the case is filed, you cannot proceed with that action until there is proper service on your customer. And that may be service that is by mail in some states. It may be a personal service in other states by actually handing it to the individual. And as Amy mentioned, in the Replevin world, because time is of the essence, and we really do not want to wait for the vagaries of the Postal Service to accomplish service, we generally use personal service to actually hand that summons to the customer and get that case moving. So you have to get initial service, so it's important we know where that person is, so we can get that individual served with the summons originally. That starts the clock rolling, so to speak, on the case. And then once you have your order, however it's obtained, whether it's through the motion stage or whether you have a final judgment for possession in that case, that order, that judgment for possession has to get served again so that the sheriff or whoever the officer is can actually take possession of the vehicle. And so it's doubly critical in your workup and in your communication with the customer and in your record keeping, even the underwriting when you first make the loan, to get as much information as you possibly can about where this individual is, where they are during the day, where they work, and where that vehicle might be. So Yes, service and location is everything. Guys?
I think you nailed it on that. I mean, we are sending law enforcement out to get your vehicle, and so if we don't know where to send them, that becomes a problem. So knowing where that collateral is helps us, and then we also secondarily need to know where your member or your consumer is.
Agreed.
So, question came in, how can we get assistance for Replevins on a military base? So somebody should chime in about the SCRA first, right? Stephanie, what do you have on
Amy,
SCRA?
I guess any one of us can talk about this one.
Go ahead, Stephanie.
So before we even start, we're going to run a SCRA search to see if our member is in the military. And if we do get a positive hit on our military, on our SCRA, we're going to look to see when was the loan taken out? Was this pre-military service, the start date? Because we can't, if it's, if our member is in the military and then takes out the loan, we might be able to go and pick up the vehicle. But if it's a loan that's entered into prior to the military service, then we're going to need to put the brakes on our repossession and Replevin action. Because the SCRA is going to provide them additional protections, and we have seen these go wrong. So make sure if you are flagging your system when you do see a positive military hit come up on your SCRA search. If we do have a situation where you've got a positive military member and let's say they do want to turn over their vehicle to you, then we're going to definitely want to have them sign off on a voluntary surrender form prior to going and picking up that vehicle. That way they're waiving any rights that they might have for possession of that vehicle. But if for a Replevin action, Amy, I think I've seen these more with a military member than I have for Replevin.
We've seen them, and we've also seen them where they're on a military base, but they're not necessarily a military member's vehicle. Those can get a little tricky. Usually making contact with the base and in fact arranging for the pickup isn't impossible, particularly if it's on a member's car. Let's say it's a friend or a girlfriend or a boyfriend or spouse or whatever. There are different things and ways to work around it. It's a little more touchy. And so without having a little more background about what you're asking, I agree with Steph on a surrender, almost any surrender. I kind of think if you can get an agreement signed about the voluntary surrender, it's a nice little added piece of protection for you. It sort of waives any claim of wrongful repossession down the road. Al, do you want to add anything?
Just that there is a specific waiver language that's in the act, and so if you do get that agreement, we can provide the waiver as needed. Okay, question number 7 is if the collateral is still outstanding after judgment, can I pursue other ways of recovery like wage garnishment? Amy?
Yes, you can if you've got a money judgment. And there's a lot of post-judgment things to think about. If you've done a 2-count complaint, you've got all the same rights you would if we took another money suit on your behalf. So that's bank attachments, wage garnishments, debtors exams, those kinds of things. Related to the Replevin itself, you also have the right to file a motion to show cause. That final order of possession has a little section, if you ever read it, that says that the defendant is ordered to turn over the vehicle. Their failure to turn it over could put them in contempt of court, which means you can do a motion to show cause. Catch a motion to show cause, there's your 3rd time that you have to get service. So again, we go back to that question about location and why it's important. But that's another way to pull that defendant back in. I have several cases right now where someone's hiding collateral or just claims not to know where it is, and we're going to use a wage garnishment. Then if you're not going to tell me where it is, you're going to have to pay for it. And so we're going to do the wage garnishment and try to get some money coming in for the client to make them whole. But that's where those 2-count complaints have some more value, is that I can hold someone accountable for not surrendering more than just a show cause order. And for all of you, a show cause is just contempt. It's you didn't follow what the judge said. There are jurisdictions that will, if you fail to come to a show cause hearing, will issue out what's called a bench warrant. It's a civil warrant. It's not like the in most jurisdictions, the sheriff is going to go out and get these people. But if they got pulled over on something else, they may get called into court and held until we get there to ask them where the vehicle is. So there's all kinds of things you can do with your judgment. But again, location's important because we have to be able to find them to execute on the judgment too.
This might be a good time to also mention that in our orders, we always add the right of the creditor to hire a locksmith to open any door, any lock behind which the car might be concealed. So they can get into garages, they can get behind fences, they can bring a locksmith to the location in order to get possession based on that provision in the order that's been signed by the judge.
And I'll point out that up here in the northern half of the state, the judges will not sign off on a break lock order. That's what Al just mentioned, unless I provide proof. And the reason behind that is it's mostly a Cleveland thing. Is we had a creditor who was repossessing furniture and putting it in all their orders, and an issue commenced about them trying to break into someone's space. So again, that's sort of a jurisdictional thing. If you have me and we get to that point, I'll probably have to file a subsequent motion and an affidavit supporting my claim. But again, all these courts are like tiny kingdoms. And so all the kings have different rules. So talk to us, ask questions, and we'll give you some good guidance on what to do.
And just to add too, if you have reduced your judgment to a monetary judgment, we can also get a lien on any real property that your consumer may own. Here in Indiana, it's an automatic judgment lien. In Ohio, we can essentially request a certificate of judgment be put on, but that's another really good tool. And again, just to add, I'm always amazed how fast a consumer will call once we file a garnishment. It's like, I've never heard of any of this. I had no idea this was going on, but once you get that garnishment going, they call so fast. And so it's a great way to get people to, I think, realize that this is a real situation and that they need to either pay or figure out something to make you whole in order for us to stop the collection process.
Okay, question number, actually, let's go to one more chat if we can sneak it in here. Is there additional requirements beside the person named when the unit is located at a third-party address? And that, I think this goes back to comments that Amy made at the beginning about who you name in the Replevin. And I think maybe she can reiterate, or maybe it was Stefanie, why and who you would have to name in that situation.
So the most common scenario that we see is that a mom or a dad finance the purchase of a vehicle in their name for a child. I think it's probably the most common one. So the son or daughter goes off to college, they take the car, they promise mom and dad they'll make the payments, and they don't make the payments, and then I file a Replevin. In that case, the son or daughter is not on the loan, right? And they're not on the title. But we have good reason to believe they're the person in possession. Either our member has told us about it, or we've made a call and they've disclosed it. The other one we see, and we'll talk about this a little more in the questions, a repair shop is in possession, or it was left at somebody's house and they're not on the loan, but we know it's in their garage. A third party in possession can't be sued for money, but they can be sued for possession. And we handle these all the time, but we're gonna want some proof. We can't purely work on a suspicion that the ex-girlfriend has a car. What we need is something, if we're going to name someone inside litigation, we want to make sure we've got some justification. The other thing we'll do is, let's say you can ID a car, it's behind a fence on this property. We're going to find out who owns the property, because we're going to name the owner, because we want to walk on their land, right, and get our car back. That owner might not even know it's there. They may not have given consent. So again, those are those third parties in possession, the most common one being the son or daughter. Sometimes it's a girlfriend. I've heard some crazy stories about third parties in possession. It's crazy who ends up with a car, angry ex-boyfriend. I have one right now where my consumer is in, I want to say Kentucky, but my car is in Ohio with the ex-boyfriend who got mad and actually took her car. She didn't file a police report. And now I'm filing a Replevin with him here in Ohio. So you'll hear all kinds of crazy stories, but again, as much information as you can give us about who has it and why we believe that, and we can do some things with that to help you get your car back.
Okay, question 8. how do you handle recovery when the government, such as local police or DEA, has seized the customer's vehicle? So this is a nice compact question that's got a very, very large answer, because every statute that involves the police authority taking possession of a vehicle and the circumstances under which the vehicle might have been taken, or where it's being held, will determine how you get it back or when you get it back. And added to that is the fact that if it's a federal agency that has possession of the vehicle, there's a whole different authority that you have to answer to and convince of your right to the vehicle. And again, the reason that the vehicle was taken will determine your ability to get that vehicle back. So just briefly as to the feds, because we don't want to spend much time on a very complicated area. When the government takes possession, or an agency takes possession, number one, watch for that notice, because the notice will, especially from a federal agency, will contain about 5 pages of instruction about what you have to do to apply to get your vehicle back. And in essence, when it's all distilled down, you simply have to prove that you have a lien on the vehicle and that you have a security interest that gives you the right to possession. But there's a lot of hoops you have to run through. Watch for that notice, watch for the application that comes with it, or a website that you're referred to, and we have to follow, you or your lawyer has to follow the instruction. When the car's been picked up because of a DUI stop, or because of warrants out, or it was involved in a crime, there are different statutes that determine how you get the vehicle back and how you apply to either a prosecutor or to another agency to get that vehicle back. So the key thing is watch for that notice. You should get a notice that the vehicle has been taken, because you are a lien holder and you're entitled to always get notice if the car is taken, and react. Do whatever is necessary at that point. Either get your lawyer involved or react to whatever is being contained in that notice in order to get the vehicle back or start the process to get the vehicle back. That's a quick answer to a very complex issue. Anybody else? Nope.
Be prepared to pay some storage on law enforcement ones, by and large, to get your car out of wherever it is. It feels unfair. You didn't do the act that got the car seized or impounded in the first place, but law enforcement is generally going to ask you to pay. If you read your loan contract, generally you can put it back in your loan. Of course, now you've got a consumer who's likely involved in a crime and maybe going to prison. But at the end of the day, don't be shocked when there's some kind of bill attached to storage, or if law enforcement wants to sell it and honor your lien, which sometimes happens too.
Actually, that's a really critical issue, and it also highlights a gap in Ohio's law, because every one of the statutes requires that you, the lien holder, be notified when the car is taken. And common sense would tell you that even if the law requires that the lien holder pay some storage or pay for the tow, for example, as part of the statute, none of the statutes say anything about who pays the storage until that notice goes out. So for example, I recently had a case where the vehicle was taken because of a DUI, and it was sent to a storage facility, and no notice was sent to the lien holder for almost 6 months, until the lien holder then got a notice from the storage facility asking for thousands of dollars in storage, when no notice had been sent until that day 6 months later. And the problem is that the Ohio law does not provide for who is obligated to pay that storage facility until that notice goes to the lien holder. And as of this minute, talking to you, there is no solution to that. It's a matter, as Amy said, that inevitably you end up having to pay some money just to get the vehicle back. All right, number 9. Getting down to it now, a few minutes left. Should I just pay a repair shop that has possession of our collateral? There's our question again, Amy.
And our answer is always going to be, it depends. my advice to clients is when they get that repair shop bill, and this is not just storage, this is repair, is first and foremost, get your collateral inspected. What's it worth? Was the work that's done worth paying for? We've had occasions where we've received repair bills and an inspection of the vehicle reveals that it's shoddy repair work. We can't put the car back on the road. And know your vehicle's worth and value. These are business decisions at the end of the day, and I would say that the best thing you can do is divorce yourself from emotionality on that and make a good business choice. Has real work been done to the vehicle that has upped or increased its value? And was that work done correctly? And is the pricing fair? And notify your attorney when you hit loggerheads. The other thing, don't let these languish. So you're fighting with the repair shop, you can't get any headway, and you sit on it for 6 months. This is not a good place to be. Whenever you can't reach an agreement with that repair shop, the first thing you should do within reasonable time is notify someone, because there are steps we can take. One's a Replevin action. Sometimes the repair shop will have a lawyer, and if I can get that lawyer engaged with me, we can have a logical conversation about what to do. But one, I would never pay for repair work I have not seen. I've heard of clients who send out checks for $500 because it's a de minimis value, but it's still $500 for work that may or may not have been done for a car you may or may not be able to sell at a decent profit. So the answer is it depends. It depends on when it's a good business choice.
So Amy and I have debated this issue, and Amy just gave you the practical answer, and I'll give you the legal answer. And the legal answer is that in Ohio, the lien holder wins that argument. The lien holder gets the vehicle over the repair shop. So in many states, probably half the states, the repairman's lien or material man's lien is superior to the lien holder on the title. In Ohio, the cases say that the lien holder has priority over the repair shop. And so if you're in court, you're going to win the case. The problem is, as Amy always points out, it costs you a lot of money to be in court winning that case. And therefore, it's often a very sensible thing to do to simply negotiate with that repair shop, remind them that they are behind your lien, and remind them that if you have to go to court, you're going to win, and remind them that they should take whatever you're offering in order to release the vehicle.
The counter argument they'll have in court is that you've been unjustly enriched by their labor. That when they took possession of the vehicle, it was worth X, and they put labor and time into it. Now it's worth Y, and it's unfair you take the gain. And that's the counter argument we get in court all the time. And I was right. The case law is very clear that our lien is superior in Ohio. It's a little different in Michigan, but he's right. He's absolutely right. Our lien is superior. What happens when you start to litigate them, though, is that counterclaims get filed and claims for unjust enrichment. They can't get to you on contract. You didn't contract with them. We have a lot of things on our side, but from a practical point, I am a practical person. Anyone who works with me knows. It depends on the situation. It depends on what was done. It depends on what our collateral is worth, and if this is the business choice you want to make.
No, I agree. I just wouldn't, don't ignore it. That's the best advice. Don't ignore it. A lot of clients will sit on it and wait and wait and wait. So just don't ignore it. Pick up the phone, contact the repair shop, contact us, because we're going to need to at least deal with it and find out what was actually done to your vehicle, if anything.
Okay, the boss is telling me that we ran out of time, so we almost made it to the end, but we've run out of time, so we'll conclude here. We want to thank you for attending today's Weltman webinar. We hope that you found the presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. If you'd please share your feedback and let us know what the future webinar topics you would like to see. I'd also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on various topics such as collateral recovery, real estate, and bankruptcy, to name a few. I will send you a link to the library in our follow-up email. Thank you again for attending, and have a great rest of your day. Thank you.
Thank you.
Thank you all.